Chris Hipkins.
Thank you very much, Mr. Speaker. Mr. Speaker, it's impossible to consider this report into the use of intrusive powers within the parliamentary precinct without considering the context of how this all came about and why we are here having this debate. We are here having this debate effectively because a Minister of the Crown was accused of releasing a report, and in the process of investigating that accusation, a whole lot of files were accessed, including phone logs, email logs, and so on, and the question arises as to whether or not that was appropriate. It related to a journalist within the parliamentary complex, it related to a minister, and it raised the wider issue of members of parliament and the information held by members of parliament. I want to make a clear distinction at this point, though, between a minister and a member of parliament, and I think we should never forget that there is a clear distinction there. A minister is covered by the Official Information Act, and the information that they hold in their ministerial capacity is public information, covered by the OIA, and with all of the rules that govern that. Very clear processes around that. Members of Parliament are not covered by the Official Information Act, and nor are journalists who work in the parliamentary complex or many of the other staff that work in the parliamentary complex. The reason that I make that distinction is very important because Peter Dunn, who was the minister accused of trying to leaking the report, tried to make a distinction during the Privileges Committee inquiry between his personal email account, i.e. I don't know whether it was a Gmail account or whatever, and his parliamentary email account and his ministerial email account. And he argued that any emails sent by his Parliament email account, he was doing so in his capacity as a member of Parliament, and any emails that he sent using his ministerial email account, he was doing so in his capacity as a minister. The reality is the distinction is not that clear. It's not the means of the transmission of the communication that matters, it's the communication itself. So it doesn't, if it's ministerial information, i.e. it's public information, it doesn't matter whether it's communicated using a ministerial account, a parliamentary account, or a private Gmail account or a Hotmail account or whatever other account you want to use. It's still official information, and it's still covered by the Official Information Act because it relates to a minister's ministerial responsibilities. If it is a parliamentary matter, so for example, ministers have parliamentary responsibilities too. They often deal with constituency matters, so if it's a constituent communicating with a member of a minister but in their parliamentary, not ministerial capacity, that's a grey area, quite frankly, and that does become a lot more difficult because ministers often, it's difficult sometimes to establish, is this a ministerial issue or is it an MP issue? That can be a grey area. And ministers need to have pretty clear protocols within their own offices about how they deal with that. But the critical thing with regard to this inquiry was that it could easily be argued that the information that the inquiry was seeking with regard to Peter Dunn could be obtained in an official capacity outside of this protocol because he is a minister. And because he is a minister, he is covered by the Official Information Act. Now, what was interesting as the inquiry progressed is it became clear that the inquiry never asked for that information using the channels available to them. They could have requested that information under the Official Information Act, and they chose not to do that. And so we got into quite a lengthy discussion with the inquiry about why that came to be. But it became very clear that there were some significant issues with the way the Inquiries Act could be applied in the future. It became clear that there was a real need to clarify the area, all of the issues and responsibilities here, and to make sure that sufficient safeguards were put in place to protect all those working in the parliamentary complex, including the Fourth Estate, the journalists, so that they could be protected from the potential abuse of power. Now, I'm not in any way suggesting that this could happen now, but without these kind of protocols in place, there is a possibility that someone in the future in government, whatever the shape of the government may be, could misuse the powers of government under the Inquiries Act to effectively delve into the affairs of another political party or a member of parliament from another political party or a journalist, and they could do that inappropriately. The protocol that we're putting in place here, that we're asking the Speaker to adopt, makes sure that that cannot happen. It makes sure that there are safeguards in place so that the incumbent incumbent government, whomever that may be, cannot abuse their position, cannot gain access to information they couldn't otherwise gain access to. There's further to come in the next report. We're going to talk about the execution of search warrants within the parliamentary complex and so on, because it actually all fits under a sort of, I guess, an umbrella of issues that govern what happens within the parliamentary complex. There are some important principles at stake here. Members of the public need to be able to communicate with members of parliament and know that that communication is going to be protected. We deal with those issues all of the time. That's very important. Members of the Fourth Estate need to know that they can function within the parliamentary complex and do their role as a watchdog, a check and balance on the use and abuse or otherwise of power within the parliamentary complex, and that they are going to be protected. Journalists have, what became apparent is up until the point of this protocol, journalists have greater protection when it comes to court proceedings and legal proceedings and so on than they did here in Parliament. And I think this protocol goes some way to addressing that deficiency and to making sure that all the rules are clear and that power cannot be abused. So I think this is a good report. It's been. I want to congratulate the chair of the committee, Chris Finlayson. I've been warned by my colleagues not to go over the top, but I think the inquiry and the deliberations around the report were conducted in a fairly collegial manner, I think, by all sides of the House. We had some very interesting discussions, and I think that the report that we've produced is a quality one. I think the next one that we're going to be debating is a quality one too, and I think that we've also done quite a good job of deliberating on the Parliamentary Privilege Bill, which we're also going to be debating. So I also want to congratulate the government in terms of the timing of when they're putting this legislation through. I think it's good to do it before an election so that it applies to the new parliament. If anything, it kind of follows the protocol that we have with the standing orders, that you make changes to the standing orders at the end of a term of parliament so that it applies to the future parliament, and therefore avoid any accusations that any current Parliament is changing the rules to suit itself. And I think the idea of having these reports go through so that they take effect from the beginning of the next Parliament, given that we've only got 2 weeks of this one left, or a week and a half of this one left, I think it's an important principle and it's a good one. So with that, I'll leave my remarks on this particular report at that. I think it's a good report. I think it's good that the protocol is going to be adopted, and I think it will provide that safeguard in the future that has been lacking.
Brendan Horan.
Thank you, Mr.